My Lords, from that interview, my Lords would have observed that Mr. Kerry was in the company of over 400 international observers. It was their observation that the vote, the integrity of the vote was protected, and that is a constitutional requirement, protect the integrity of the vote. My Lords, agents were present. Agents agreed to the tally at the polling stations. The percentage of the agents has been tabulated or indicated in the e-log report is over 90%. And very important, my Lords, if there's any problem with transmission of the Form 34A, one simply goes back to the manual 34A, because as our Court of Appeal said, it is the primary document. So we shouldn't have a contest on transmission. We should have a contest, if any, on the numbers in 34A, because those numbers can only speak one voice. You cannot therefore found a presidential petition, engage the apex court on questions of transmission, because transmission at the end of it all is a conveyance. It is not an originator. Responsibility is underscored, a responsibility on all the political players across the board, because what they are doing is litigating the rights of Kenyans, not their individual rights. My Lords, given all that, would it be possible or would it be viable to challenge this outcome on the basis of infractions at municipal law level? We go to the infractions that have been advanced before you. My Lords, one of my learned colleagues for the petitioners took a lot of your time going through the affidavit of Dr. Oduo, in which a multitude, a whole litany of grievances are set out. Those grievances can be described or categorized into two groups. Group number one, contentions that for his candidate or for the petitioner, at one point he had 10 votes, but what was posted is 8, so a deduction of 2 votes. And for the third respondent who had 10 votes, he is increased to 1 vote, and then it becomes 11 votes instead of 10. And he took that, a whole region, and very, very many paragraphs. The next category is the non-numerical category. The category where forms, he says, are not clear, or they are not signed by agents, or the forms are so faint you can't make anything about them. My Lords, those are the complaints which are the basis upon which a very exaggerated with respect a submission was made that the elections were shambolic, and being shambolic, they should be declared invalid so that a re-election can take place. My Lord Chief Justice, I do recall, asked the counsel, what is the effect, what is the numerical effect of all those complaints? And there was loud silence. Let me now take the hint from that question and deal with the numerical effect of all those so-called irregularities. May I request the court clerk, if you could, is an annexure to Winnie Nguchu's affidavit, subheading alleged numerical discrepancies. Maybe other judges as well, if you have copies. Very well. It would appear the clerk had only one. My lords, at page 1, what we did is to take all those allegations and anticipate the question, because that question must be raised. What is the effect of those numerical discrepancies? So, my Lord Chief Justice, starting with the first one so that I can indicate, we have dealt with the paragraph. Number 1, we have dealt with the paragraph where the allegation is. The allegation is, it is not indicated petitioner had 66 votes, yet in Form 34B, it's indicated 56. My Lords will recall the 66 and the 56. Then our response, false. Petitioner had 56 votes in Form 34A, same as 34B. Total tally is indicated. So, my lords, we have gone to the extent of saying where it is a false allegation. The allegation that the petitioner had 66, and then that was reduced to 54, is a false statement of fact. And then we have dealt with it all the way to the end. And at the end, because at the end of it all, we ought to be looking at what numerical difference. My Lord, if you could turn to the last page, the petitioner is the third one, starting from the right, where you see 822 votes. From all the discrepancies, each one of them, all that the petitioner would receive is an additional 822 votes. From all the discrepancies, 822 votes. Analyzed allegation per allegation. Then the third respondent is the candidate with 974. Again, from all the discrepancies, the third respondent's vote tally would reduce by 974 votes. Is my Lord with me? Hence, my Lords, from all those so-called discrepancies, the end result is, and I use this word deliberately, insignificant. Totally insignificant. My Lords, in the fullness of time, you will see how many are false allegations and how many are true allegations. Where it is a true allegation, my Lord, we have tabulated it for the petitioner for the benefit of this court. We have done that which the petitioner had a duty to do, which is say these are the irregularities, but demonstrate numerically what do they read to. My Lord, We now go to the non-numerical discrepancies. We go to the non-numerical discrepancies. And against the non-numerical discrepancies, that goes hand in hand with a document, the bigger no, the bigger one, yeah. It goes hand in hand with this other document, analysis of alleged non-numerical discrepancies, because we had to give, to place before you the documents themselves. And let us start with the first one, my lord, the one on regarding Form 34A as uploaded on number 2, first page, my lord. No, the big, yes, because that's the summary. Yes, we go to number 2. In paragraph 139, the contention is Form 34A as uploaded in the Commission's portal are not clear or legible. Our response is false and true. The form attached are clear and legible. This is in Mombasa, Jomvu, Miritini, World Bank. Where do we get that document? We go to this bundle. Yes? Yeah, oh good. My Lord Chief Justice has it. And then the first page is about paragraph 139. Write the first page, paragraph 139. And then, my Lord, we'll see the Form 34A is attached to it. It is quite clear, it is quite legible, and more important, is signed by all the candidates' agents. My Lord has seen that? And then, if my Lord could bear with me, turn to the second one, still at paragraph 139, page 10, handwritten page 10, just to demonstrate the falsity of these claims. It is contended, it's not clear, but my Lord, at page 10, handwritten page 10, you see the document there is quite clear, as well as the next one is quite clear, yet the affidavit evidence before you is that those documents are not clear. Why have we gone to this extent, my lords? We have gone to this extent to demonstrate before you that all these allegations are untrue. They want to portray a picture of shambolic elections, whereas, to the contrary, the elections were fairly credible. And despite having presented this evidence before you, it was quite shocking for my legal team to sit in court and listen to these accusations one after the other about 66 votes being reduced to 54, whereas we have presented all the evidence before the court and served our learned friends so that they could, so to speak, reflect, have a self-referential moment and see whether they want to advance that theory anymore. Self-referential is a movement that costs nothing. It only costs one, his conscience, and his moment of silence. My lords, why did I use the term insignificant? I use the term insignificant because of the results that were declared. The results that were declared were that the third respondent had 8.2 million votes out of the 15 point something million votes, and the petitioner had 6.8. The difference, quantitative difference, was 1.4 million votes, approximately. I say approximately because there will be a few thousands and a few hundreds. But let me deal with rounded figures because it will be easier. A difference of 1.4 million is significant. It is a difference that shows the will of the Kenyan electorate. And when one compares with the numerical differences which have been brought before you of 800 votes, then those numerical differences can only be said to be quite insignificant. That is not to say that we for one moment countenance even a single vote being taken from the first petitioner to the ballot of any other person. We do not. But we appreciate that is our fellow brothers and sisters who are doing this tallying process in very difficult circumstances. Circumstances which have received judicial recognition in our courts. Kenyans want the outcome immediately. The clerks have been working the entire night and the entire day. So errors of addition may arise. But it is an electoral contest. It's not surgery in theater. While liars, we have demonstrated that our worthy opponent votes tally 800 were deducted by error. What must be said, my lords, and I want to say it as humbly and as firmly as I can, that was not at the instance of the third respondent. He had nothing to gain from an extra 800 votes. He would not even countenance such an error, but we accept. As a matter of fact, if a similar exercise was carried out for the third respondent, and we have carried it out, we lost about 2,000 votes. Some posted to the candidate just next to us. A place where my client had 100 votes is posted to Wainaina. And Wainaina has 0 vote is posted to my client. And those things do happen. At the end of it all, my lords, one is looking at the greater good of the process instead of what is scientifically a scientific impossibility. My lords, I move to the next point, which is a complaint on rejected votes. I would wish to associate myself with the submissions made by Ahmed Nasir. Those rejected votes have been analyzed in a similar exercise as we have analyzed, and the analysis will be in the affidavit of Mr. Davis Shishil. The rejected votes at the last presidential election was approximately 81,000. It is our submissions that rejected votes cannot be taken into account in the final tally. It was a point that we argued in 2013. Nothing has changed since then to warrant a departure from the judgment that this honorable court made. Apart from the principle of stare decisis, there is a greater principle that in these electoral contests, which is nothing more than a political contest being now brought to court, that there should be a fair degree of predictability, a fair degree of uniformity in the judgments from the court, so that our political players do not all the time seek a departure from what has been decided previously. My lords, the next point I would wish to deal with is about polling stations without adequate coverage. The coverage was either 3G or 4G. My lords, prior to the polling date, my lords, it is common ground that political parties were informed, and Kenyans too were informed, about 11,000 polling stations which did not have adequate 3G or 4G network. And they were informed that the results from those polling stations will not be streamed as instantaneously, or the images from those areas will not be streamed as instantaneously as the polling stations where there was adequate coverage. My lords, we must accept one thing, that these telecommunication players do go where there is good business for them. So in places where there isn't a lot of our brothers and sisters, they may not find it very lucrative to invest a lot of infrastructure. So there are indeed places in Kenya without 3G or 4G network. In those areas, my lords, it's not that the voters were disenfranchised. On the contrary, voting took place. The votes cast in those places are captured in the affidavit of Davis Shishil, and in total, 3.5 million voters were in those areas, and their votes have as much of value and weight as the votes in other regions. So, my lords, it cannot be, and it's not a legitimate argument to say that this election should be invalidated because of anything about the 11,000 polling stations. On the contrary, the voting on those areas took place, and the votes were taken into account as the votes from all other regions. All of them, without one vote being lost. And that is why, if I could elaborate a little, my Lord Chief Justice, we are in agreement that the polling stations in Kenya are 40,883. And even in the video by the late gentleman from IEBC, he refers to 40,800. We are in agreement. And the figure of 40,883 includes the 11,000. So it is not that this is a different segment from other polling stations. They are the same. And that is why this repeated complaint becomes impossible to understand. Because since all these are polling stations with Form 34A, if there's a legitimate grievance, why not go to the primary document, look at the raw data in the original form, not even in a transmitted form, but original form, and go through all these 34As, do a national tally, and come up with a result. My Lords, I go to the next point, which is ungazetted polling stations. The less I say about this, the better I believe. There was only one polling station that came into being pursuant to a judgment by the High Court, and the votes from voting did take place, and the votes were included. And again, since it's a polling station, the votes do not in any way affect the difference, the quantitative difference between the two candidates. What I mean, my Lord, is this is a polling station. The polling took place due to a High Court judgment. The decree is before you. The numbers that voted in that polling station are well indicated. The voters in that area had a constitutional right set by Article 38 to participate in the election of their candidates. And that cannot be a complaint adequate on its own to invalidate a national election. My Lords, I have dealt with everything at a municipal law level, because one is dealing with transmission, one is dealing with tallying, complaints about 3G network and everything. My Lords, all those do not come to the level of invalidating an election conducted in accordance with the Constitution, in our humble submission. I then move to the accusations against the third respondent. The first accusation against the third respondent is that he went to Makueni, threatened and intimidated chiefs so that they could all parade Kenyans in that area to vote for him. That allegation, my Lords, has been dealt with incisively and decisively in an affidavit by Dr. Kibicho, who is the Principal Secretary, Ministry of Interior, in paragraphs 22 up to 25 of his affidavit. It is noteworthy, my Lords, because this is an accusation against the third respondent, that Mr. Kivisho deponds, and it's not controverted, that he, Mr. Kivisho, received intelligence reports that certain chiefs were campaigning for candidates in that area. The names of those chiefs are deponed too in the affidavit. And they were campaigning for a political party, which is NASA. And he passed that communication or that intelligence to his appointing authority. And when the third respondent was in that area, he actually told all public officers in very general terms that none should campaign for anybody, and not even himself. And when politicians take to the microphone and say, look, people, let's engage, we'll be here, this country is larger than all of us, let's not do politics, that is not a threat. It is what is expected of people in public office. The results in that area, my Lord, tell the truth. One could look at the antithesis of the hypothesis that was put forward. First, petitioner garnered 301,000 votes from Makueni. 301,000 votes. Despite the so-called intimidation, my client received a paltry 27,000 votes. A small decimal of what the first petitioner received. So where is this intimidation? It is disproved by the results at the poll. It is disproved by the fact that no chief was suspended from duty. It is disproved by the fact that no chief has ever been terminated from employment. It's therefore unfair, my lords, quite unfair, for an accusation of that magnitude to be made, directed at another political player, that you intimidated persons or intimidated public officers, whereas the opposite is there. The opposite is the true position. Still with the affidavit of the Principal Secretary, the next accusation is that the third respondent went to Kisii and Nyamira talked to the IDPs in those regions and bribed them to vote for him. Those allegations, my lords, have been denied by Mr. Kivisho in his affidavit, starting from paragraph 6 all the way to paragraph 19, in which he deposed, my lords, and this cannot be denied, that this difficulty of IDPs started after the post-election violence of 2008. Successive governments have tried to resettle the victims. The current government in office, in its own budget, provided funds for the persons who had not been resettled. That budgetary provision, my lords, and this is quite important, received approval from the National Assembly. These are not funds taken away from somebody's pocket. It's the National Assembly that approved that budget. And as a continuous process, IDPs are resettled throughout the country. And the resettlement of IDPs in Kenya is within a body that is deponed to in the affidavit, and which is known as the National Consultative Coordination Committee. It is that body that disburses funds to the victims. National Consultative Coordination Committee. That is the body that gets funds. The funds are approved by National Assembly, and they are disbursed directly to the IDPs. My lords, there is no evidence before you that any of the beneficiaries, be it in Kisii, Nyamira, or any other part of this country, because they are IDPs also in the strongholds of the first petitioner, and they were also resettled, there is no evidence that any one of those beneficiaries was influenced by what he or she received as a resettlement from National Consultative Coordination Committee. Not a single iota of evidence. My lords, the next accusation, or before I deal with that, I leave that, there is indeed a direct authority that for any aspect to do with bribery or influence is got to be established that the inducement acted on the mind of the voter. Inducement acted on the mind of the voter and made the voter alter his decision. There can't be an inducement, so to speak, in generic terms or in general. It's got to be an inducement that is specific and induces the voter to alter his mind. We shall make this judgment available to this honorable court before we rise. No, I understand we have already submitted. Sorry? This case is a high, let me get it. It's Andrew Elam against Mohammed Rahman from the High Court of Justice, Queen's Bench Division. Mohammed Rahman. R-R-A-H-M-A-N. Inducement must act on the mind of the voter and must be operative at the material time. Next allegation against the third respondent relates to Cabinet Secretary Mucheru, who is in charge of ICT in government. I start off by making this submission that that allegation is not in the petition. It only came to our notice yesterday in an affidavit that was served yesterday and which we begged time to respond to as the petitioner was presenting their case. What is this? My lords, Mr. C.S. Mushero was never served with that affidavit, and within the limited period that we had, we were able to prepare, file, and serve an affidavit by Mr. Shishil, court-stamped 28th August 2017. It is not alleged, my lords, that Mr. Mushero was campaigning for any party. What is alleged is that he was interviewed and he said he is entitled. Is that correct? Yes, he said he is entitled to campaign. So the allegation is based on an answer to a question. And surely an offense cannot be made or the answer cannot be the charge sheet of an accusation of such magnitude. Mr. Mushero indicated his view about political neutrality, and citing Leadership and Integrity Act, he indicated that as a CS, he is entitled to participate in the affairs of government, including making such campaigns or advancing government policy as necessary. So, my lords, in my submission, that complaint falls flat on its feet because it is ill-founded. What is it? The next one is about CS Eugene Wamalwa and Mwangi Kionjori. I'll deal with them all at the same time, and Kazungu and Barara. All those allegations came yesterday in the affidavit that was filed, and those named persons were given no opportunity to respond to any evidentiary material that was presented. And I say this once again, those are not accusations or allegations that are in the petition. Those four persons, their names are nowhere in the petition. The petition? In the petition, my lords, after dealing with all the municipal law issues, the only reference to the third respondent, I'll get it in a moment, 31. The only reference to the third respondent is in paragraph 31. And the one that would be more pertinent to this would be 32, which reads, no, petition, yes. Petition, with impunity, I read, with impunity, the third respondent contravened the rule of law and the principles of conduct of a free and fair election through the use of intimidation, coercion of public officers, and improper influence of voters. No reference to any person. This is very generic, imprecise, without any particulars, and at most refers to public officers. The cabinet secretaries cannot be called public officers. They are state officers. My lords, one cannot make such a generalized allegation at the tail end of the petition, now, so to speak, drop in names of persons and give them no opportunity to give a response to those accusations. I will therefore request, my lords, to hold and find that all those allegations against the cabinet secretaries are without any foundation and to dismiss them. There is such a fundamental distinction between the public officers and their role and state officers. I have dealt, my lords, I hope, with quite a number of all the allegations against the third respondent, but I will deal with a few more because of the prejudicial effect they have or they may have on the mind of the court. Substantial time, my lords, was expended on transmission of votes. So I take that as another subheading, transmission of votes. It is common ground, my lords, that early this year, our National Assembly amended the Elections Act and infused it with technology as one of the methods that elections should be held. But let's understand where technology fits in the electoral process of 2017. Technology was there at voter registration. Voter registration was biometric. So there was full involvement of technology at voter registration. Polling date, voter identification by use of the BVI kit. Where it failed, and it failed in certain circumstances, the complementary method was used. After that, the ballot paper was manually given to the voter. BVR is BVR kit. The voter manually inscribed a symbol on the ballot. And all the processes after that were manual, including the counting and including the filling in Form 34A. All that process, which is the most integral process in the elections, was manual. And it concludes with Form 34A. Now that Form 34A, and we now see the rationale of it, you want elections or the results to be declared fairly quickly, is to be transmitted electronically to the constituency and to the National Tallying Center. But that transmission, my lord, is nothing more than a conveyance or a conveying mode of a document. As I indicated earlier, it does not validate, neither does it take away or add to Form 34A. Because of its very insignificant weight, insignificant, my lord, because as we have seen, agents at the polling station signed the same forms. So each and every candidate will be able to know at the end of the day the number of votes the candidate obtained at every polling station. There's no magic in the transmission of Form 34A. My lords, in our submission, the whole purpose of this electronic transmission is a fast way of conveying the results to the constituency and to the National Tallying Center. Once that purpose is defined and delineated in those terms, any failure, not that there was any failure, but even if there was any failure, it cannot invalidate the results. Not the results at the polling station, not the result at the constituency, not the result ultimately declared at the National Tallying Center. It will be stretching logic to an illogical conclusion to say because transmission failed at this point, then those results are declared, all the results are declared invalid. I would therefore urge you, my lords, to hold that although there was no failure in transmission, even such failure in future cannot be the basis to invalidate an election which was otherwise constitutionally compliant with all the articles or all the operating articles of the Constitution. My lords, before you are two positions, or what I will refer to as two realities. Reality number one is presented by the petitioners, and the reality, to put it very modestly, is that you allow another electoral contest to take place within the next 60 days. That reality, my lords, would mean that this nation, for the next 2 months, will be engaged in very, very contested political climate where all manner of utterances will be made. It will engage all of us for the next 2 months until the contest is held. It is the reality, I can only describe it as a reality, which is the reality presented by the petitioner. Kenyans will be treated to the political jargon that we are now accustomed to. Attorney General reminds me, vifaranga via computer is one slogan.
Doing that as an amicus.
Let me speak for myself, my lord. My Laden colleague sought to know from me whether I knew of any of this. I made no answer because I didn't. But he took the liberty of a man in mid-speech.
Take care, Mr. Attorney General. At least you find yourself being classified as partisan.
No, it was with a light touch, my lord. I know that is taken in good standing. Yes. There is nothing derogatory about it in my submission. A quick rejoinder is made by the other parties. We need not go to that. But all that is the rhetoric, unhealthy rhetoric in an electoral contest. Compare that, my lord, or before we compare it, let's still look at this reality and what it presents. It presents that this nation will have to contend with another presidential election. With all the invasive aspects of a presidential election. My lords, we are trained in such a way that we can make that reality look like a legal contest. a legal contest like we are advancing the rule of law. We are not really here advancing the rule of law. We are advancing an opportunity for an electoral contest. The other reality presented by the third respondent is this, my lord. To allow the third respondent move on with constituting a government, he has offered a hand of fellowship to the petitioner, offered a hand of fellowship to all Kenyans that it is time to go back to nation building of this great nation. I paraphrase, without the eloquence of the third respondent, that the time of elections are over. Let us go back to building this nation. If given that opportunity by this noble court, what I look for or look forward to is an inclusive government where each and all Kenyans will be participants. That is the reality that I'll urge this honorable court to find favor with, because we cannot be in an electoral mode throughout our lives. There is no guarantee, my lords, absolutely none, that even if we were to hold another round of elections, those minuscule errors or by clerks will not take place. They will still take place. But those errors are so insignificant that they do not affect the result of any outcome. I conclude my submissions. Yes, I am told by my assistants, my lords, that as regards there was a complaint about there being such a big difference between the people who voted for in presidential elections as compared to people who voted for the other elections. Before we play the video, let me say this, that we have in the affidavit of Davis Shishil demonstrated that there are indeed peculiar Kenyan habits, even in voting. In certain areas, and we have identified 94 areas, you will find that the outcome at one election was so high as compared to all the others. And that is nothing more than that the people in that area were, in all probability, voting for one candidate who was their favorite candidate. Say, for example, a member of parliament may get more votes in that area, more than even the governor or the president. Which one? The presidential. That's it. Number two, before we play the video, is to show, my lords, that if you compare Jubilee Party election results for the post of governor or the post of senator or woman rep, members of parliament, you see that in all of them, the results are in the region of 53 to 60%. 53 to 60%. We play? Yeah, just show okay. Script. Now we'll show a short clip and then I'll be concluding. You and your team are about that. Yes, it won't take long. So do I explain this? Okay. No. It's not a clip. It's just a video. So for the presidential, that is what we have. Our client had 54.3%. Then we go down to the gubernatorial. He had 53.2%. And the next one is now the pattern
The one marked red represents Jubilee. We can see that it is more than half of the map of Kenya, and that explains the number of governors. Jubilee has 25 seats. We have KANU, which is an affiliate party, which has 1. That takes it to 26 seats. Way down to the Senate election results, we find that Jubilee Party has got 51.1%. The Senate election results, Jubilee, the voting pattern is as shaded, representing the 51%. Parliamentary election results, we find that the Jubilee Party has 48.6%, together with other affiliated parties as shown. Then we go to that is the total number of the positions. We go to the women representative. At the women representative, we have Jubilee having 55.3%. The voting pattern is shown. Then finally, that is it. Thank you. Thank you.
So, my lords, from all those results, and these are 6 elections held the same day, you will see, my lords, that the result for the president is not dissimilar, and that is the point I wanted to make, is not dissimilar from the results in the other 5 elections. As a matter of fact, one would say they all follow within the same range. So any aspect about votes being added, votes being deducted, it's really not scientific. It has no basis, and it's yet another allegation, which is a red herring. I therefore conclude, my lords. I started from a constitutional argument point of view because in my submission, a contest regarding presidential petition or presidential outcome ought to be litigated within the confines of the Constitution at the very least, or bearing those articles in mind at all times. And in my submission, the quantitative test is at the highest level. Highest in the sense that one must gain not less than 1/2 of the votes cast. That is unique to the presidential results. It's not similar to the other 5 results. In the other results, actually one who has even 21% or 20% or whatever percent could be declared the winner. Number 2, my lords, having demonstrated that elections were held within the expectation of the Constitution, it will be unfair in my submission to invalidate them for infractions, which infractions we have demonstrated do not exist. And finally, my lords, that as regards the accusations against state officers, those allegations are without any basis whatsoever. They were not pleaded in the petition, and they cannot be, so to speak, added at the tail end of the hearing of this petition. My lords, my learned friend, Mr. Ahmed Nasir, will now conclude all the